In tort law, a duty of care is a legal obligation which imposes on an individual to provide a standard of reasonable care while performing any acts that could forcibly harm others. Before 1932, if there is an absence of privity, there would be no duty of care. The test of duty of care came in after the case Donahue and Stevenson in 1932, which established neighbor principles. In this principle, the defendant can only be held liable if there is proximity and forcibility. In 1978, the two-stage tests were established in the case of Ants and Merton. The first stage test is similar to neighbor's principle, while the second stage test is policy consideration. The law has developed over the years. The current test to establish the duty of care is the Kaparos test. It includes proximity, forcibility, and fair, just, and reasonable. In tort of negligence, there are three elements, which is duty of care, breach of duty of care, and damages.
On this part of the presentation, I am going to be assessing on the relevance of the Bolam test under the tort of negligence. The Bolam test was established after the case of Bolam and Fearn Hospital Management Committee, whereby a doctor will not be held liable if what he had done would be endorsed by a body of medical experts at that particular time. The test has been seen by some commentators as a test that has been established by medical profession, evidenced by expert testimony, and allows minimal court scrutiny. Hence, allowing a more stricter evaluation of the test is always welcome.
So, the subsequent decision in the case of Bonito and City and Health Authority has suggested that the court should adopt a more interventionist view in assessing expert evidence and also in setting the standard of care.
As per Lord Brown Wilkinson in his argument stated that a medical practitioner would be held liable if it is unsatisfactory that the advice and opinion of the medical expert is made reasonably and responsibly. Hence, even if the conduct of the medical practitioner is compatible and would be endorsed by a body of medical experts, they would still be liable. So, to this extent, we can agree that the Bolam test, as accompanied by the decision in Bolito, should prevail in avoiding all the possibilities in making doctors liable. However, this should not always be the argument. In this 21st century, where human rights is already on the verge of its zenith, and people are more educated to acknowledge their rights and to stand for their rights, should the law cease to focus on duties of doctors and prioritize patients' rights? Should the tort of medical negligence today depart from the old medical law, which puts doctors at the heart of proceedings at the expense of patients? Having these concerns in hand, we can say that the Bolam test also has its own drawbacks. Despite the usefulness of this test, it also has a certain degree of irrelevance for it to be applied in the current era of technology where certainty of the law is made important. These concerns can be answered in the more recently decided case of Montgomery and Lanarkshire Health Board concerning a medical practitioner who failed to warn a pregnant lady who suffered from diabetes that if she insisted in delivering the baby by the normal vaginal delivery, there is the possibility that the baby would be born with shoulder dystocia and further disabilities. The omission to tell was on the grounds that, as referring to Lord Templeman in the case of Cedar Way, the provision of too much information would prejudice the whole purpose of attaining the patient's health. Hence, the baby was born with shoulder dystocia, and the mother then claimed for the negligence done by the doctors for failing to inform her. And the claim succeeded, because if otherwise the doctor had told her of the possibilities and the potential consequences of the damage, it was not in dispute that the baby would be born unharmed. This decision in the case of Montgomery, as referring to the case of Rogers and Whittaker in Australia, have established the extent that information to be disclosed to patients is now assessed by the test of materiality. The materiality test was defined as whether in the same circumstances, a reasonable person in the patient's position would attach significance to the information provided by the doctor, or that the doctor would foresee that a patient would attach significance to the information that he is supposed to provide. This was used in the Malaysian case of Dr. Hari Krishnan and Megat Nur Ishaq, which went up to appeal in the federal court. The case concerns a patient who had undergone a retinal detachment operation conducted by Dr. Hari Krishnan. The attending anaesthetist was Dr. Manavalan. At a post-surgery follow-up, the patient claimed that he has been suffering from pain post the surgery and also pressure in his eye. After some physical and visual inspection by Dr. Hari, he informed the plaintiff that the retina in his right eye had folded and detached. Hence, the plaintiff needed to undergo another surgery due to the urgency of the situation. The plaintiff did undergo the second surgery. He requested Dr. Manavalan to be the attending anaesthetist. However, during the surgery, the attending anaesthetist was Dr. Namazi instead. While the operation was ongoing, the plaintiff regained his consciousness, and due to the pain of the operation, he bucked while Dr. Hari was strengthening his retina using laser. As a result, he had a total loss of his vision in his right eye. He made a claim on the basis that the doctors had failed to inform him of the possibility of regaining his consciousness and bucking during the operation, and the possibility of him losing his vision. The claim succeeded as referring to Rogers and Whittaker on the grounds that if otherwise the doctors have informed him of all those possibilities, a reasonable man would attach significance to it.
Another interventionist approach that has been established by the Department of Health in assessing expert evidence and also in setting standard of care is by using medical guidelines. Medical guidelines are established in order to help assist clinicians in making decisions of treatments in specific conditions. These guidelines are systematically developed on the basis of evidence in order to promote efficiency and also effectiveness of the healthcare delivery. Based on the medical law review, which talks about the role of clinical guidelines, it has been suggested that the clinical guidelines serve to inform standard of care and provides an added dimension to the evaluation of standard of care. Hence, it promotes a move away from the hardline Bologna test.
Today, I'm going to talk about the relevance of tort of negligence in terms of employer and employee relationship. Although tort of negligence has been subjected to heavy criticism over the years, it's undeniable that this area of law remains highly relevant till date. The leading reason for its relevance in employer and employee relationship would be ultimate aims and purpose. It is a well-known fact that tort of negligence seeks to regulate involuntary interaction in private setting when such interaction harms someone. Accordingly, tort of negligence aims to correct and compensate for past harm in a measure that is roughly equivalent to the plaintiff's loss, and accordingly, acting to deter violation, also shape future conduct. Despite the claim that tort of negligence has many numerous goals, but special attention needs to be drawn to its distributive effect, as tort of negligence is more often than not seen to promote equality, especially in terms of power, status, and well-being of the disadvantaged due to its distinct imbalance of bargaining power of both these entities. Hence, it goes without saying that this area of law remains relevant. The tort of negligence paves a systematic path for average people to be able to influence powerful corporations and employers who often place profit at the top of priority lists. Accordingly, it is a law of tort that influences these profit-minded businesses to change their business practice and policy. It were cases like Donahue and Stevenson and also Watson and Bulkley that ultimately paved way to and brought positive changes in the marketplace itself, where most of the company resorted to redesign their product, improve their warning, and even recall their dangerous product from the marketplace itself. For instance, Mars had to record thousands of chocolate milk drinks in 2014, where it was found that the said drink contained elevated levels of bacillus bacteria. Although there exists legislative intervention in the form of strict liability statute, namely Consumer Protection Act 1987, the tort of negligence remains relevant, as in the case of Commission of European Community and United Kingdom went on to show that if the defendant can prove that the state of technical and scientific knowledge that he has at the time when he put the product into circulation was not such as to enable the existence of the defect to be discovered, then the defendant may avoid liability. Hence, it was clear that, unlike tortious liability, there exists a wide number of defenses that is available for the defendant under Consumer Protection Act 1987 to help them avoid liability. The tort of negligence prevents employer from prioritizing profit ahead of worker safety. The prospect of paying hundreds of thousands of pounds of damages keep most of the corporation on their toes and duly refrain from harmful conduct, thereby prevent injury in the first place. Although there exists a series of legislative protection accorded to workers that guarantee a safe working environment, ranging from Factory Act 1833 to Factory Act 1961, Employer Liability Act 1969, and Health and Safety at Work Act 1974. The tort of negligence remains the main channel of getting compensation and also fill in the lacuna by this legislation. In the mid of 20th century, there were numerous limitations on the liability of employers, specifically in the form of the doctrine of common employment, where the employer can only be held liable if it can be shown that the employer were personally liable by carelessness in selecting the workers. But the decision in the House of Lords in the case of Wilson and Clyde Co. held that an employer had a non-delegable duty of care for all employees. This principle was later adopted in the case of Woodland and Swimming Teacher Association and others, which largely went on to say that the employer must provide a safe working environment. This principle was also adopted in Malaysia, which is decided in the federal court in the case of Dr. Kok Chung Sing and Su Cheng Lin. The tort of negligence remains extremely relevant for the type of liability an employer has when there's a scientific uncertainty of the cause of injury. The House of Lords in Fairchild and Glenhoven Funeral Services Limited went on to impose tortious liability onto the plaintiff employer for the wrongful contribution to the risk of the injury, even it cannot be proven that there is a causal contribution to the injury itself. This is once again reflective of the distributive effect of the tort law as actively trying to promote equality between the employer and their worker. Furthermore, in the case of Chandler and Cape, the court held that even a subsidiary company is the direct employer of the worker. A parent company is still said to owe a duty of care to prevent the shareholder from systematically hiding behind the corporate view to escape the obligation of safety and health at workforce.
The police in a moment of help and they don't turn out until it's too late. But while you may want to drag them through the court, your chances of winning for now are probably nil. That's the result of an important Supreme Court judgment that the police cannot be sued because they have a special position in public service and under the law. For example, if a barrister bungles your case, you can sue, but you can't take the same action to the police in the same way. This is what the family of Joy Michael had tried and failed to do. In Michael and other and the Chief Constable of Southwell Police and another, Miss Michael was 25 and murdered by her former boyfriend. Her former boyfriend broke into her house, after learning that she had a new man in her life. He threatened to kill her, beat her ear, and took the other man into his car. Then, Miss Michael made a first call 999, but unfortunately, her call went through the wrong control room. And by the time the patrolling police officer were on the case and the call had been downgraded. After her former boyfriend returned to her house, she made a second call, and the control room had actually heard her scream, but then after 15 minutes later, Miss Michael was dead. Since then, the police officers had made their apologies, but they can't be sued for negligence damages, which could probably support Miss Michael's children. And the Supreme Court, by majority of 5-2 decision, held that there is no police liability to Miss Michael. Secondly, basic position on police liability in cases involving the policy decision. In Hugh and Chief Constable and West Yorkshire, the last woman to be killed by Peter, the Ripper, was Jacqueline Hugh, who is the student in Leeds University. Her mother, Mrs. Hugh, tried to sue the police for failing to use the reasonable skill and care as he sought to apprehend the Ripper during 1975 to 1981 for murdering 13 young ladies, and he attempted to murder the another 8. Hugh's claim was struck out by High Court in 1985 as being impermissible as a matter of law. In other words, no matter how negligent the police may have been, she was not allowed to sue the police officer for not preventing her daughter's death. As well as pointing to the lack of proximity between the police and the young lady who was killed, House of Law indicated that there were good policy reasons for not imposing the duty of care on the police, which is the fear of being sued might cause the police to compromise their work in order to avoid the liability. Hence, in this case, the police had no duty of care to the victim. The police had no duty of care to prevent crime and could not protect every single woman in West Yorkshire at once. There is another very important case, Robinson and West Yorkshire Police. In this case, the claimant was an elderly lady who was knocked to the ground during the arrest of drug dealer by the police. The claimant suffered a personal injuries and made a claim against the police. The police in this case was held not owed a duty of care to the claimant during the police operation. Court of Appeal stated that there is no duty of care imposed in this situation, because to impose a duty of care in this case would be no fair, just, and reasonable. And according to Lady Justice Hadley, most claims against the police in negligence will fail the third stage test of the Caparo test. It will not be fair, just, and reasonable to impose a duty of care. However, there is a new judgment from Supreme Court, which is the police officer no longer immune from being sued for negligence. On 8 February 2018, Elizabeth Robinson successfully appealed the decision in her case. The case of Hugh and Chief does not give the authority for proposition that the police can enjoy the general immunity from suit. The effect of this case is that the police do not owe a duty of care. Applying the principle from Hugh, the police have a duty of care to protect an individual from danger which they have themselves created. Also, it was held that the appellant's injuries was caused by the police breach of duty of care. The Supreme Court unanimously found that the defendant is liable for the appellant's injury. The police ought a duty of care under the ordinary principle of negligence as do other persons.
I will talk about tort of negligence under the children category. The law of tort, unlike the law of contracts, does not draw a sharp line of demarcation between minors and adults. Again, unlike criminal law or any other law, there are no similar rules or exemptions from liability or torts committed by children. However, the age of a child does have a bearing in those cases where mental element in tort or reasonable care is material. In relation to wrongs committed against children, similarly a greater degree of care may be expected than adults. Complicated legal problems have arisen when injuries suffered by a child were partly attributable to his contributory negligence. Negligence means one of ordinary care, example, that degree of care which may reasonably be expected of a person in the plaintiff situation. However, the special position of child arising from immature judgment has been duly recognized by courts in this regard. This could be illustrated by a few cases. Lynch and Nardin, the defendant, left his house and car unattended in a busy street. A plaintiff, which was a boy under 7 years of age, climbed on the cart and another boy led the horse on. The plaintiff then fell down and broke his leg. In a suit of damages, the defendant contended that the plaintiff were guilty of contributory negligence. Lord Denham dismissed this argument on the ground that the degree of care which might be expected of a young child of plaintiff's age would be very small. This overflow was applied in Yacho and Oliver. A tort of negligence is said to be liable under the category of children, as they are the vulnerable one. A child is generally responsible for consequences of his or her wrongful acts. However, the degree of reasonable care required of a child depends on the age of the child. In Walmsley and Hunick, the plaintiff, aged 5 years, was struck in the eye by the defendant of the same age in the course of play. The court held that the defendant was not liable, since he had not reached that the stage of mental development where it could be said that he should be found legally responsible for his negligent acts. On the other hand, in Gordy and Court, a boy of 16 years old was held liable for negligence when he accidentally shot the plaintiff with an air rifle in the course of lacking about. It is well established that tort law may impose a duty of care when there is a special relationship exists between the plaintiff and the defendant. For purposes to protect the children, there are two relationships, which is parent and child relationship and school-pupil relationship. The duty imposed on schools who acting the character of parent is more onerous. It is because the schools have the obligation to ensure the children's safety, whereas the parents cannot do so. Authority of parents and of schoolmaster over pupils. According to Winfield, parents and other persons in similar positions have control, usually but not necessary, of disciplinary character over those committed to their charge. The nature of control varies according to the relationship and provided that it is exercised reasonably and moderately. Acts done in portions of it are not tortures. A father may beat or imprison a child by way of punishment so long as he acts reasonably. Parental authority ceases when the child attains the age of majority. The control of a schoolmaster over his pupil is delegated to him by the parent. This includes implied assent of parent to any reasonable rule or custom of the school relating to discipline, whether the parent knew it or not, unless there is a specific understanding that a particular rule should not apply to a particular student. Further, a schoolmaster's authority is not limited to school premises. In the King and Newport Justice, 24 corporal punishment was inflicted on a student for smoking outside the school after the school hours, in violation of a rule absolutely prohibiting smoking. The court upheld the punishment on the ground that the parent, while admitting him into school, had impliedly acceded to that rule. The Malaysian High Court too went on to embrace this principle in the case of Jajlin Jahira Hazi Kamuruzaman dan Satu Lagi.
Today I'm gonna talk about the negligence under the food industry. For me, plays a role in the law unlike the Bible plays for Christians or Torah for Jews or the Quran for Muslims. It inspires the noble thoughts and deeds which we need more in the modern world, not less. It challenges us to dream about a beautiful world where people care about one another, feel responsible for one another, even love one another. This was the statement made by Alan Linden about the decision of the Donoghue and Stevenson's case. This was the case where Lord Atkin introduces the neighbour principle. Donoghue's case is a very famous case. In that case, the appellant consumer appealed against the dismissal of her claim under negligence against the defendant, who is the manufacturer. Mrs. Donoghue had drunk a bottle of ginger beer which was bought to her by her friend. It was an opaque bottle and coincidentally it contained a remains of a snail which could not have been detected until the majority of the drink had been consumed. Mrs. Donoghue suffered shock and severe gastroenteritis as a result of consuming the ginger beer. Although Donoghue and Stevenson established a duty of care and the neighbour principle in general, a duty of care towards the consumer by the manufacturer arose indirectly. R and Zaman is the recent case that followed and applied the Donoghue's case to take a reasonable care of the consumers. R and Zaman is a case where restaurant owner persistently failed to take reasonable steps over several months to make sure that the customer who are suffering from peanut allergies were not served meals containing peanut. He did not improve his system even after one customer had suffered a violent allergic reaction, that consequence to a death of another customer after suffering from an allergic reaction. This case was named under a single alleged breach, namely that the restaurant owner did not take a reasonable steps to prevent injury to the customers with declared allergies. It is concluded that the restaurant owner definitely owes a duty of care to his customer, especially to those known to have food allergies. The judge considered that the owner of the restaurant had consciously and deliberately changed from almond powder to mixed nut powder in a bid to cut costs. He was well aware of the risk. Thus, the restaurant owner was sentenced for 6 years imprisonment for gross negligence. Manslaughter. As quoted by Lord Justice Hickinbottom, in any event of dismissing the restaurant owner's appeal against sentence, his negligence was just not gross. His behaviour, driven by money, was appealing. In a nutshell, the thought of negligence for the food industry is still relevant today as it protects the customer from the manufacturer or anyone under the food industry. Each and everyone owes a duty of care towards the consumer as they have a close relations with them. Of negligence is relevant in today's modern world. For example, the negligence by the police officer would not immediately excluded by his so-called immunity. The police officers owes a duty of care towards each and everyone, and a police officer can be sued under the thought of negligence. On the other hand, children's required a reasonable care differs according to their age and circumstances. The rule for children will differ to an adult as they are minor and they could not foresee the consequence of their action. Moreover, a consumer has to be protected from the manufacturer or any other food industry, as the restaurant owner and the manufacturer can kill consumers with the poison or contaminated food. As discussed earlier, the thought of negligence is relevant for the employer and employee relation. Thus, the thought of negligence is still relevant in today's world. However, it is not relevant for the medical negligence. It is still discussed and argued that the Boehm's test is not relevant in today's world. Thus, it can be concluded that the thought of negligence is relevant to a certain extent only.
Thank you.
Thank you.
Thank you.